Hello, everyone. This is Gilbert Gelot. I'm talking to you here from Private Corporate Counsel, downtown Orlando. This is Tufts On Tax, where all your tax issues and answers are right here with Mr. T. Scott Tufts. When it comes to taxes and tax law and litigation, he is the expert and the master. Hello, Scott. How are you today?
Hey, good to be with you.
Good to be with you, too. And you can reach Mr. T. Scott Tufts at 407-647-7887. That number is 407-647-7887, or you can email him at stufts@pcc.law. That's stufts@pcc.law, or you can visit our website at privatecorporatecounsel.com. Hello, Scott, and today we are talking about a tax break that applies to small businesses.
Yeah, so, when businesses get up and running and they operate and hopefully hit some successes, the business owners oftentimes will think ahead or get to a point where the opportunity to sell the business might come along. And if at the point of sale, most people know that you would be inclined to move toward an asset sale, to a buyer would, because a buyer does not want to buy the liabilities. So they don't often prefer a stock sale. Now, the seller might prefer a stock sale. And in the past, it would be because maybe there would be favorable installment sale type treatment for taxes or whatnot. But that's, so there's tension between the seller and the buyer of what they might want. But there is even a greater incentive for some of our audience out there, if they have a business, a small business, and they look to sell their business, they would want to look at Section 1202 of the Internal Revenue Code, a tax provision that gives a 50% exclusion of the capital gain in certain circumstances as to a stock sale. Okay, so it's a big tax savings, and you can't ignore it, and you don't want to ignore it. So if you're an accountant out there, advisor, you'd want to look at this criteria and and see if you're in the game for that, right? Because then it becomes part of the conversation, part of the planning, part of the opportunity. So if you've got a corporate model, right, and you want to partake of that, then you're on the right track, right? Now, you can also be an LLC and elect corporation status, so don't lose sight of that, because we've talked about the asset protection advantages of LLCs versus the stock. But that gets into, though, what is the requirements of 1202. And one of the things that's going to come up here is the literal nature of the provision itself. And a case has come out of the Court of Federal Claims in 2024 here called Tongzhong Ju v. United States. So that's TONGZHONG JU and then v. United States.
Can you give us a brief about this case?
Yeah, so let's talk about it. So, we want folks to know about cases that come out when we can. And this one's out of the Court of Federal Claims, which is a place you can go when you seek a refund of your taxes, when you believe that the taxes you've had to pay are wrong and you want to sue to get your money back. Claims court is not like district court where you can get a jury trial, but it's dedicated to tax issues and other type of matters that are particular to the claims court. So there are times when, if the law's on your side, you'll say, "Hey, I want to take this case to the claims court." But in any event, the husband and wife there were looking at a sale of stock. Now, what's interesting there is Dr. Ju in that case received from the University of Oklahoma, where he previously worked. He had an arrangement specific to earning stock interest in something that he invented. Okay, so he had an arrangement as working at a university where he had created something, and it exchanged itself into a company that was licensed to. The patent rights were licensed to a company. That company then at some point gets into a sale. between him and the university, they have a splitting of the stock right. And so it gets into the details of that contract. Now, what was important is that when you look at section 1202 of the code, and what this provision says is taxpayers can exclude half the gain from the sale or exchange of qualified small business stock. Okay. So you then say, and it says the further requirement is it's allowed if the taxpayer acquired the stock at original issue and held it for more than 5 years, and if the small business meets the definition of what is a qualified small business. So for our purposes, essentially less than 50 million of assets at all times is the kind of rule of thumb. So larger businesses beyond assets of 50 million would not be qualified small business stock. But for your smaller businesses, then you're in the game for this, and you want to look at it, and you want to look at, but the key here is, what does it mean by acquired the stock at original issue? Okay, this is kind of like, what does that mean? And original issue starts to feel like, oh, you have to be eligible here. They want to get the persons eligible for this would be those who start with the business, right? Original issue of the stock. So it's the founders, it's the original stockholders.
When we were talking earlier about this topic, and you gave me this example, simple example about getting a break on that money in the business.
Yeah. So let's walk that through.
Yeah.
So you have like, let's say you put up 100,000 of capital for the business. Yeah. You take back stock of 100 shares. So far, so good. So you capitalize with 100,000. You start a business. More than 5 years go by, and it sells for $2 million. Okay, we're talking about $1.9 million of gain if you sold the stock. Agreed? You have $100,000 of basis in your stock. You sell it for $2 million as part of a sale of the company. Someone buys it for $2 million. You'd be looking at $1.9 million of capital gain. Under this exclusion, half of that is excluded from taxes if you're eligible. And then you got the favorable capital gain rates for the other half.
I thought that example very simple and also puts it in perspective.
Yeah, so we're looking at taking 900,000 out from under the the capital gain component, and then you're only looking at taxing the 900 with favorable capital gain rates. So it's just an awesome tax advantage if you can meet it, right?
Do a lot of people know this is available? This can be done, or this is a law?
Well, I think it affects how you plan business, because a lot of times folks will say, why don't I always be an LLC, or why don't I, how do I pick what type of entity I want to be? And if you have your eye on growing a business, but you're more entrepreneurial and you're looking at selling it, you may say, okay, but what about that 50% exclusion? Am I in the game for that? Early on. Now, maybe you make decisions not to, maybe you say, I'll just go LLC or some other classification partnerships, and you give that up. But the point being that from the moment you're starting and planning and building a business, and at private corporate counsel, the idea is that the persons in the growth of the business, owning a business, thinking through these issues, this is an early on issue, because the exclusion is only going to be eligible for those who have original issue of these securities, right?
So you got to think ahead when you're planning your business, when you're starting your business.
Yeah, and one of the things that's going to come up here is, so back to the case, Dr. Ju had argued in the case that he had acquired the stock and it was intended that he have it from the beginning. But the actual stock itself, the certificate, was dated in 2015. Okay, and he had a couple, I think, stock certificates. All right, and that is because at the point of sale, or as part of a resolution with the university, they issued him the shares under their agreement that they had going all the way back to 2003 when the business was created. Okay, so the problem was he didn't have the stock from the beginning, but he had an argument that, well, I really was the intended shareholder, or I was, I was kind of underneath the university and I had this legal right to those shares. You follow me?
Does he have it on paper?
Nope.
Oh.
Well, no, but he had a contract.
Oh, okay.
So he started arguing, well, that's what the contract intended, or that's what that's what the intent of the parties were.
Intended, but does it clarify it?
Right. So let's say the language in the agreement said under an agreement you will get, X number of shares.
Oh, I see.
You see what I'm saying? But you don't have them. So here you go. This case says you don't have them. And you got the other side arguing, yeah, but the spirit of it was that it was mine, or the all intents and purposes were it was mine. You were holding it for me. You see where that's going? So this is kind of back to what we've said about the tax law, the gotchas, the fine print. So you can't just, I'd love for our audience to say, okay, it's a knee-jerk thing, one rule fits all and all that. But every time we hit this, we get our general idea, and then when you dig into it, you realize there's it's like a recipe. There's details in it that you've got to go through, and that's the spirit of this one as well. And what happened was Dr. Ju thought it was pretty much a opportunity for them to view it broadly and say that he held it all intents and purposes because he had this arrangement, and he said that should meet it, and he should qualify for all the shares he got. And the claims court said, nope, not so fast. We're not going to let you qualify as to a larger portion of those shares because you only got them just now. And then even as to some of the argument that he had that they should have been issued in his name originally, even if they in 2015 said that, right, Gilbert? So that you don't have a stock certificate done in 2003, it's done in 2015, but the effort is to try and say, yeah, we recognize you had this right since then. Even then, the court was not willing to say that will work without further a trial on it, okay? And so the government wasn't going to get summary judgment either there. They looked at that issue more closely, but they also had to look at the threshold of what a small business is under this definition, which was the 50 million. And Dr. Ju didn't have records going back all the way for the company. And the court there said, hey, look, we're going to hold you to that. You got to show it at the original issuance that it was worth less than 50. Even though it appeared, remember in 2008 there was the crash. So the court said, hey, look, we're coming right after a crash, and yeah, we're satisfied that it might be less than 50 million in 2009 or 10, but you need to be able to have the proof that the aggregate gross assets of the company at the point of issuance back in 2003 was did not exceed 50 million, less than 50 million, 50 million or less. So so that was kind of because he was able to show in 2009 it was worth, the assets were 2.15 million. But he couldn't show back in 2003. So this is kind of like, I use the basketball analogy, since it's tournament time with March Madness or whatnot. You have, sometimes you have proof problems with tax issues as well because you're sure you made the shot before the buzzer, but you can't tell whether it was a 2-point or 3-point play. With taxes, sometimes you better prove 2 or 3, and if you can't prove and you're stuck between 2 and 3, you may get 0. So you have to be able to go through that and figure out where you want to end up. So that was the case, and that's why it caught my attention, because once again we see that the tax law doesn't give us simple answers. It might give us a great concept to work with as a planning thing, but your accountant and your advisors need to be right at your side as you build your businesses and think about these issues, and even at the selection of the business, because this exclusion is at original issue. So if you take it literally, you'd want to be a C Corp with that exclusion with original issue and plan that business accordingly because you expect to be able to sell it that way. You see what I'm saying? So very important.
So what do we come out from this case, an advice to the audience?
Yeah. So the audience would benefit from knowing that if you're thinking about this exclusion, make sure you're thinking, do you have it documented? That's number one. Documented how would be question two. That would be your stock certificate. Make sure your corporate book's in order and you're looking at how things were issued originally. Number three, if you're starting to think about a business, think about this as a planning option and decide maybe this is where you see your business going and you want to preserve it, and therefore you err on the side of having a corporate model, even though you hear all the scuttlebutt about, hey, let's do an LLC or something else. So you say, not so fast. Let's look at this exclusion. Is this going to be, do we think we're going to have a lot of growth and a lot of things, and we're going to want that capital gain exclusion opportunity? And then fourth, I think this case also tells us that if you get in litigation over something, lots of little catches. So if you hear a lot of talk in this case about, I know it was titled in the name of the university for the holding the stock, but it really was mine. You see how that goes? So that raises for our audience the other part, which is, yes, it is true the tax law is driven by the benefits and burdens of ownership. What do I mean by that? Title isn't everything. So our audience needs to know that just because you have title, that's a large portion of it, but there are lots of arrangements where things aren't as they appear. And so if you have title, but you're really holding it for somebody else, who should pay the tax? The somebody else. Agreed? So our audience can't be fixated completely on title if there's something else going on where the real owner, the de facto owner. And this is where corporate transparency is going, because if you know the Corporate Transparency Act that's out now affecting our businesses, when they form, they're looking at, they want no more shell companies. They want to know who really is the movers and shakers behind the entity, and then they are the ones. So that's what we call beneficial owner, right? Well, what does that mean? It means that if you're in a trust, we want to know who the beneficiary is. That means if you're really the one that's benefiting from it, they want to know it. If it's, you follow me? If you've got tiered entities of an LLC owning another LLC owning another LLC, they want to go all the way down the chain to find the human being and look for that as the ultimate mover and shaker. So these reports are very important, and that gets us back to the argument made in in the Ju case, because they were arguing, hey, I know it's titled in the university, but we have a contract that says it's really mine. And they made the argument. And the court said, it's not what the statute says. Statute says original issue securities in your name. Now, they tried to paper it up, right? After the fact, come back and say, that's what we intended. And that's where the dispute comes in, because on some of the shares, they were arguing that they rolled back effectively. So you see that? So they're not out yet on that argument, on that one part of the argument. But they couldn't get all the shares in because they were issued so many years later.
And if anyone falls into a situation like that, in a case like that, you'll be able to help them?
So this was a refund case. So this comes in where they've paid the tax based on a certain position, and they're saying that they get the money back because they have a claim to make that they were eligible for this gain. So if you think about it, you overpay and then ask for it back in the refund situation. It's not a situation where you get audited. You took, it could happen that way. You could claim the exclusion. IRS say you're not entitled to it, take it away, and now you owe tax. But the other way to go about it is you can say, this is an aggressive position, or whatever, I'm going to pay it. Or sometimes you filed your taxes and you catch it later. Then you go, okay, we're going to do an amended return and we're going to seek a refund, right? And we want some of the money back, and you want interest. So refund litigation is kind of interesting because you're soon to get your money back, and the government has to pay you interest if you're successful. But it's a whole different dynamic and a different court. That's why our audience also needs to know, we have tax court here, then we got claims court and federal district courts. So that different type of court is a whole nother aspect of litigating claims or tax issues, because you got to know which court you want to be in. So, but anyway, back to the business idea. This tells us, hey, keep your, you got to be in the game for this exclusion. Well, you got to be in the game from the get-go.
Be prepared.
Yep. Talk to your accountant. Get the good advice up front. Set the business up the way you're anticipating. A lot of businesses do think they're going to sell. They're going to grow and sell and parlay that into success. So, many in our audience will know what I'm talking about. The 1202 50% exclusion is something to be thinking about and holding on to, because it's 5 years and then you're in the game.
It sets the foundation for the future.
Yeah, very much.
Well, you heard him, folks. Think ahead and plan. Great advices from Mr. T. Scott Tufts. You can call him at 407-647-7887. Again, that number is 877. 407-647-7887. There's an 800 number as well, 877-647-7887. You can email him at stufts@pcc.law, or you can visit the website at privatecorporatecounsel.com. Thank you, and until the next episode. Thanks.